My name is Steve Palazzolo, and I'm an attorney at Warner, Norcross & Judd, LLP. I'm here today to talk to you for a little bit about harassment. But before we get started talking about harassment, I want to set a couple little ground rules here. First of all, I am an attorney, but I'm not your attorney. And this program doesn't create an attorney-client relationship, nor is it attorney-client privileged. So just so you know that, I want you to know that. The purpose of this is educational. It's not legal advice, so keep that in mind. Every situation is different, and if you have a harassment situation you need to deal with, we want you to call your lawyer and talk to them about the individual facts in the case you're dealing with. So, with all that said, we're going to talk about harassment today, and we're going to talk about some of the background and how we got where we are today, and some of the rules and some of the things that I want you guys to think about as members of management when you're confronted with a situation like this. So, where are we? How did we get here? Where did it all begin? You guys all know who this guy is, right? It's funny because I called our marketing department and said, hey, can you look over this presentation? And they called me back and they said, well, I've got a picture of yourself in your sexual harassment training program. Oh, come on, I'm better looking than that guy, don't you think? That's why I grew my beard out a little. I didn't want people to mistake me. This is Harvey Weinstein. And this is where it all started, right? Except it's not really where it's all started. But guys like Harvey Weinstein and Roger Ailes, and even to some degree Bill Cosby, have become poster people, if you will, for sexual harassment, and certainly for the Me Too movement, which kind of elevated all of this up into the consciousness, if you will, so that people became more aware of this issue. Harassment's been around for as long as there have been men and women and men and men and women working together in the workplace. And there's statistics that show that. We've got up here on this slide now what we call EEOC charge statistics. And for those of you that don't know, try to say that 4 times fast. Charge statistics. And for those of you that don't know, the EEOC is the Equal Employment Opportunity Commission, and it's the federal government agency that enforces Title VII and the harassment laws of the country. When you file a complaint with the EEOC, it's called a charge, and these are a list of the charges that were filed alleging harassment from 2010 to 2019. And as you can see, those numbers are pretty consistent. They didn't spike a whole great lot when Harvey Weinstein came on the scene. There's always been an issue with harassment in the workplace. It's not a new problem. It's a problem that we've been dealing with for a long, long time. So that raises the question, all right, where did all of this come from? What's the origin of harassment in the workplace? What's the background? How did we get to where we are from a legal perspective? Well, let me tell you. We start with Title VII of the Civil Rights Act of 1964. This is a federal statute that prohibits discrimination in the workplace on the basis of a list of what we call protected characteristics. And that list is right there: race, color, sex, national origin, and religion. Now, what don't you see up there? And whenever I ask that question to a live audience, hands go up and everybody says, I don't see same-sex sexual harassment or same-sex discrimination or sexual orientation discrimination. And you're right, you don't see that up there. But that is a protected category, thanks now to the Supreme Court of the United States. But what you don't see up there is the word harassment. Title VII prohibits discrimination in the workplace on the basis of race, color, sex, national origin, and religion. Now, there's other federal statutes that deal with age, and other federal statutes that deal with pregnancy, and other federal statutes that deal with disability, and other issues like that. But these are the protected categories under Title VII. And Title VII prohibits discrimination in hiring, in firing, in compensation, and in all other terms and conditions of employment. So that's the federal law, if you will, that we're dealing with, the backdrop that we're dealing with when we talk about harassment in the workplace. But there's also Michigan law on harassment. And discrimination and harassment in Michigan are prohibited by the Elliott Larson Civil Rights Act and the Michigan Persons with Disabilities Civil Rights Act. Okay? Elliott Larson also has a list of protected categories. And it's broader than the federal list. Now, part of that reason for that is because, we learned. And the state has broader categories. We've got race, religion, color, sex, which includes pregnancy and childbirth or other medical conditions related to pregnancy and childbirth. We've got marital status, national origin, disability, age, height, and weight. Those are all protected categories in Michigan. And like under the federal law, it's illegal to discriminate on the basis of one of those protected categories. It's illegal in hiring, it's illegal in firing, it's illegal in terms and conditions of employment. But again, you don't see the word harassment on that slide. And I didn't just leave it off for kicks. I left it off because it's not in the statute. So how did we get where we got? Well, we got there thanks to the courts. The issue of harassment evolved over the years, and we start with a case called Meritor Savings Bank versus Vinson that sort of invented, if you will, the concept of harassment in the workplace. Then we had Harris versus Forklift Systems, Burlington Industries, and most recently a 2020 Supreme Court case called Bostic versus Clayton County, which said that Title VII's protections against discrimination and harassment because of sex include sexual orientation and gender identity. So as I told you, you didn't see sexual orientation on that list for Title VII, but it's there now thanks to the Supreme Court of the United States. Harassment is there now thanks to the Supreme Court of the United States. And it starts with Meritor Savings Bank. So let me just give you a little hint of what we're not going to do a lot of talking about case law in this thing, but I do want to talk about this case because it's really, really important for how we got to where we are today. It all goes back to 1974, which is interesting, right? This started in 1974, and it wasn't resolved in the Supreme Court until 1986. 12 years for this thing to wind its way through the court. In 1974, at the age of 19, Michelle Vincent was hired as a teller trainee at the Meritor Savings Bank. It wasn't called that then, but that's what she was hired at, and the bank is in Washington, D.C. She reported that by May of 1975, so a year later, her supervisor began what would be what she called 3 years of recurring sexual harassment while in the workplace. In November of '78, she was fired from her job, which Taylor, her supervisor, explained as being due to her inordinate use of sick time. The bank argued that the relationship between Ms. Vinson and her supervisor was wholly and completely voluntary, and that it wasn't coerced at all. And because it was voluntary, it couldn't be discrimination or harassment. Ms. Vincent argued the complete opposite. Even though it was voluntary, it was unwelcome, and it was a result of the power relationship between her boss and her, that he in fact coerced her into this relationship. And what the Supreme Court ultimately held was this: in order for conduct to be sexual harassment, the conduct has to be unwelcome. But the Supreme Court also said that even though the victim voluntarily participated, in this case, in the conduct, it could still be unwelcome because of that power relationship. And voila, sexual harassment was kind of born. Or at least the legal rights you have to be free from sexual harassment was born, thanks to the Supreme Court of the United States. And this has all flowed through the jurisprudence of the country now, and it is part of the law, and it's well settled. There's no questions or issues about it anymore. So what do we need to know about harassment? What do we need to know? First thing we need to know is the harasser can be a man or a woman. We talk generally about powerful men doing bad things, people like Roger Ailes, people like Harvey Weinstein. But this is not just men harassing women. Increasingly, women are working their way through the corporate ladder. They're getting higher and higher into organizations. They're getting more and more power, and they're also becoming harassers. All right? The victim doesn't have to be the opposite sex. That was true for a number of years, but it is completely true now, thanks to Bostic, that 2020 Supreme Court case that brought sexual orientation in as a protected category. So we see a lot of what we call same-sex sexual harassment cases now. The harasser can be the victim's supervisor, it can be an agent of the employer, it can be a supervisor in another area, but beyond that, depending on the kind of harassment we're talking about, it can be a coworker, it can be a non-employee, it can even be a customer or a vendor or somebody who's visiting your workplace. Harassment can occur outside of work at social events, whether or not the company sponsors a social event. Where you have a a power relationship between a supervisor and a subordinate, that power relationship is always there. And even though the supervisor may not be acting as a supervisor at the bar at night, the next day when the supervisor and his subordinate come to work, he's going to be the supervisor again, or she's going to be the supervisor again. Harassment can occur without economic injury to or discharge of the victim. And the victim doesn't even have to be the person harassed. It can be somebody affected by the offensive conduct. With all that in mind, what are we here to talk to you about? Well, we want to talk to you about your roles and your responsibilities with respect to sexual harassment in the workplace. What do you do when you see it? What do you do when it's reported to you? What do you do to make sure it doesn't happen in your department and on your workplace? And what do you do when somebody complains? So let's start with a legal definition of what sexual harassment is, okay? The EEOC defines sexual harassment as unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when submission to or rejection of the conduct is made either explicitly or implicitly a term or condition of employment. That's one. Two, the submission to or rejection of the conduct by an individual is used as a basis for employment decisions affecting that individual. Two, or the conduct unreasonably interferes with an individual's work performance and creates an intimidating, hostile, or offensive work environment. So that is the federal definition from the EEOC of harassment, and that encompasses within it the different kinds of harassment that we're going to talk about throughout the course of this program. Now, we also have a Michigan law definition, and this, rather than being in the regulations, is actually in the statute. It's been codified in the Michigan statute. Now, I'm not going to read this to you because it's basically the same thing. The state tends to be a little more wordy, but it's basically the same thing. So we have these various kinds of harassment that we have to deal with, which gets us to the issue of what do we have in common between these three things? Well, the first thing you have to have in order to have sexual harassment is you have to have unwelcome or unwanted conduct. You like my drawing? It's not my drawing. My son did it, actually. I'd tell you why it's up there, but it's a long, sordid story, and it doesn't really matter. But I guarantee you that cat didn't want his ears pulled by that monkey. Now, how the monkey got in there with the cat in the first place, I don't know. But that's a pretty good illustration of unwelcome or unwanted conduct, right? So the first thing you have to have is conduct that's unwelcome or unwanted. And remember, go back to Vincent. Just because the conduct was voluntary doesn't mean it was unwelcome or unwanted. According to the EEOC, a general definition of unwelcome conduct is that the challenged conduct must be unwelcome in the sense that the employee didn't solicit or incite it, and in the sense that the employee regarded the conduct as undesirable or offensive. Okay, that's a EEOC's general definition of what unwelcome means in the context of sexual harassment. Whether sexual statements are unwelcome is determined by the recipient's perception, not by what the employee who said it intended. That's something you need to be very, very careful about, because you've heard this before. I was only kidding. You probably heard it on the playground when you were a kid. Some kid does something, another kid says, I'm going to kill you. When I was a kid, that stuff was said all the time. Not much anymore because of the environment we live in and how much more seriously we take a comment like that. But then you would call the child in and you would say, why did you say you were going to kill Bobby? And what's the kid say? Oh, I was only kidding. I was only joking. You hear that in a work environment too. An employee says something offensive to another employee, and you bring the employee in, and what does the employee say? The first thing out of their mouth, I was only kidding. Well, I was only kidding doesn't matter. What matters is how the person hearing the statement felt, how it impacted them. It's not the intent of the person saying it, it's the impact it had on the person hearing it. So I was only kidding is not a defense. Now that seems a bit extreme, doesn't it? I mean, what if you've got somebody who's really, really sensitive? What if every time somebody swears in front of an employee, they're offended by it, and they go and complain. Is that harassment? Is that a hostile work environment? Is that the kind of harassment we're going to talk about? Well, there's some protections built into all of this, okay? There's two components of determining whether conduct is unwelcome. It is the impact, not the intent, but the EEOC is going to look at two different things, a subjective component and an objective component, to determine whether or not statements or actions are unwelcome or unwanted. The subjective component is that the harassment must result in a negative effect on the person being harassed. In other words, you actually have to be offended. Not just say you're offended, offended. Well, how do we determine if somebody's actually offended or just saying they're offended? I'll tell you a really good tool for this now. A really good tool for this now is social media. So you will often hear an employee say, I was super offended by what my supervisor said. That joke was terrible. I hated that joke. It offended me and mortified me. And then we go on that employee's Facebook page, and what do we find? The exact same joke that they said was mortifying when it was told to them. Subjectively offensive. It's got to be subjectively offensive. But again, you're stuck with what the employee is feeling there. So you also have to have an objective component to this. And the objective component is this. The harassment also must be of the type which would negatively affect a reasonable person in the plaintiff's shoes. Well, what is a reasonable person? A reasonable person is a legal fiction. It's an average person, not an average man or an average woman, an average person of average education, an average. So what's really a reasonable person? Well, what really ends up being the reasonable person for purposes of the law here is this. It's the 6 people who are sitting on the jury. They're going to determine whether or not that conduct was objectively harassing. Now, let me give you this one hint right now. And this is coming from a guy that's been doing this for 30 years and has sit and watched juries deliberate about issues like this. The last thing you want to do is put your fate in the hands of 6 people who couldn't get out of jury duty. Because the things they think are important are astounding. But that's the way the system works. This objective component is going to be determined by that jury, and they're going to decide whether or not the conduct was objectively harassing and whether or not you're liable or whether you're not liable. Now remember, with all of this being said, voluntary submission to sexual harassment can still be unwelcome. And I'm going to give you a real life example other than Vincent. Let's say you had a bunch of people standing out on the floor and they're telling dirty stories and dirty jokes. And an employee is standing there listening to all this and yucking it up and laughing along with everybody else. And then that employee goes and complains. You can't just say, well, you were out there laughing too. Because the employee can then claim, hey, the only reason I was out there laughing was because I was afraid if I objected, I would be ostracized by my peer group, and I can't have that. I'm already uncomfortable enough in this environment. So keep in mind, voluntary submission to harassing conduct can still be unwelcome, thanks to Vincent versus Marriage Savings Bank. All right, when there's conflicting evidence as to welcomeness, the EEOC will consider the following. They're going to consider the record as a whole and the totality of the circumstances. What does that mean? What that means basically is that the EEOC is going to look at every single bad thing that has happened to that employee. It doesn't necessarily have to be a sexual thing for it to be a bad thing. I've seen things like keyboards being glued to desks and desks being turned upside down and things being hidden and stuff that an employee needs to do their job being taken away and locked away and stuff like that. So it's the totality of the circumstances that the EEOC will look at when they're determining the issue of welcomeness. So that's the baseline, right? We've got to have unwelcome conduct. And we often say that around here joking around. The conduct has to be unwelcome. So that gets us to types of sexual harassment. Once we get past the issue of unwelcomeness, what are we talking about here? And traditionally, there's 2 types of sexual harassment, but we're going to go with type 1 and type 2A and 2B types of sexual harassment. And I'll tell you what I mean by that in a minute. All right, type 1, the most, not common, but the most recognized form of sexual harassment is quid pro quo. Quid pro quo sexual harassment literally means you scratch my back and I'll scratch yours. And it really doesn't mean that at all. It literally means this for that. I'll give you something if you give me something back. And then we have hostile work environment sexual harassment, which is an entirely different kind of sexual harassment, and that's where we get 2A and 2B. Now, those two types of sexual harassment are absolutely encompassed within those two definitions that we already talked about, the EEOC's definition and the state of Michigan's definition, and they're encompassed within those bullet points that we talked about. So what is quid pro sexual harassment? Like I said, it's give or take, this for that, all right? You do something nice for me, I'll do something nice for you. If you don't do something nice for me, I'll do something bad to you. That's quid pro quo sexual harassment. It's pretty simple. And I would have said to you, if we were doing this training 10 years ago, this sort of thing doesn't happen in the workplace anymore at all. Supervisors have gotten really smart. They don't do this anymore. And then we had Harvey Weinstein. And then we had Roger Ailes. And then we had all of the issues that we've had with these powerful people doing really horrible things to their subordinates. And I would have been wrong. Not the first time in the last couple of years I would have been wrong. But clearly this sort of harassment is still taking place in the work environment, and it is still a problem. Okay, quid pro quo sexual harassment is unwelcome sexual advances and requests for sexual favors or other verbal or physical conduct of a sexual nature when submission to a rejection is made a term or condition of employment, or submission to a rejection is used as a basis for employment decisions. So quid pro quo sexual harassment it's the first two prongs of that EEOC definition that we talked about earlier. You've got to have a power relationship for quid pro quo sexual harassment to occur. You got to have that supervisor-subordinate relationship. Otherwise, when I threaten to, fire you if you don't do something nice for me, nice as far as I'm concerned, not nice as far as you're concerned, you're just going to laugh at me because I've got no power over you if I'm just a coworker. But if I'm a supervisor, I do have power over you. And that's quid pro quo sexual harassment. Now, that's the kind of sexual harassment that we think about when generally we think about sexual harassment. And it's the kind of sexual harassment that you see in the movies all the time. The really old movie with Michael Douglas and Demi Moore where she was the harasser and he was the harassed. Power relationship, supervisor-subordinate relationship. The next kind of sexual harassment we want to talk about is hostile work environment sexual harassment. And this broadens the base of people who can commit or create a hostile work environment. It's not just supervisors anymore. A hostile work environment can be created by a coworker or even by a third party. For example, you've got a receptionist sitting at the front desk, and that receptionist has to sit at the front desk. He or she can't get up and move, can't get up and go away because they got to be there when people come in, and they've got to be there when the phone rings. You've got a guy comes in and fixes the copy machine that sits right next to her desk. He doesn't work for you. He works for the copy machine company. But he now starts to say things to the receptionist, do things toward the receptionist, make the receptionist uncomfortable. He doesn't work for your company, but he can create a hostile work environment that you have an obligation to take care of. The place we see this the most is in restaurants and bars. You know that suave guy who goes in and gets all drunk and thinks that the waitress all of a sudden, who's being nice to him because she works for tips, by the way, is madly in love with him and can't live without him, and he starts getting obnoxious. That can create a hostile work environment for that waitress or bartender or waiter. So that's a third party that's unrelated to the employer. Now, the employer's got an obligation to do something about that when the employee complains. So what are we talking about when we're talking about hostile work environment? What examples of conduct can create a sexually hostile work environment? Well, here's a list. It's not my list. It's the EEOC's list. And the EEOC says that physical touching can create a hostile work environment, and that makes sense. All right, what are we talking about here? Are we talking about if I put my hand on your forearm to comfort you when you're having a bad day, or are we talking about something different? Well, I mean, clearly what we're talking, anybody ever coached kids? I coached kids. In baseball, back in the day, 10-year-olds, right? They run off the field, you give them a little pat on the backside, great play. Now, put yourself in the boardroom and somebody gives a good report and they walk out and you give them a little pat on the backside and say, great report. Get away with that on the baseball diamond. You're not getting away with that in the boardroom. And I know that's an extreme example, but I'm saying that to illustrate this. It's not all touching that we're talking about here. If I bump into you in the hallway, or if I pat you on the shoulder to get your attention, or if I touch your arm, that's not the kind of touching we're talking about. We're effectively talking about what I like to call creepy touching. So I don't know if any of you have seen these billboards on the sides of the highways where there's somebody sitting at their desk and somebody behind them rubbing their shoulders, clearly making the person sitting at their desk uncomfortable. And those billboards are put up by plaintiffs' law firms that want to sue you for sexual harassment. That's the example that they're using on their billboards, creepy touching, all right? Sexual comments, suggestion, jokes, or innuendos. That should be obvious. Those things can create a hostile work environment. Suggestive looks or leers. What are we talking about here? Well, we're talking about, I call this the kids in the back of the van syndrome. You know, Mom, Bobby's looking at me funny kind of thing. You would think that that's not an issue here, but actually it is. And often it's an issue after somebody complains about harassment. You don't fire the employee who did the harassing. These employees then run into each other, and the employee will say, he's looking at me funny, she's staring at me, it's making me uncomfortable. Sexually oriented noises. I'm not even sure what this is. I don't know, wolf whistles, you know, stuff like, you know what I'm talking about, the old Tex Avery cartoons. That kind of thing, that's what we're talking about. Sexually oriented noises and displaying sexually suggestive materials. Now, when I was a young supervisor back in the day before I went to law school and ruined my life, the Snap-on tool guys used to come to our plant, you know, a couple times a year to sell the mechanics tools. And what did they hand out when they came? Anybody know what the Snap-on tool calendar is? Those Snap-on tool calendars were on every single mechanics toolbox in the bakery I worked in. There were tools on the Snap-on tool calendar, but you had to look for them to find them. Mostly what they were was people in bikinis. That's what we were talking about 40 years ago. It's not what we're talking about now. We've gone way beyond that because now we have the internet. And some of you have run into this situation before where you're walking by somebody's office and you see their computer screen and you go, whoa, did I just see what I thought I saw on that computer screen? So displaying sexually suggestive materials can also create a hostile work environment. The EEOC goes on to say that derogatory comments and sexually stereotyped insults, like, again, this is not my list, this is the EEOC's list, because I guarantee you I have never written the word stud, boy, or hunk in the same sentence in my life. But that's what we're talking about here. We're talking about calling people by stereotyped names, okay? Now, we all know the little old lady in the cafeteria line who calls everybody honey. Is that what I'm talking about? Do you have to tell her she can't do that? What about the janitor who calls everybody sweetheart? Do we have to tell him to stop doing that? If somebody complains, you probably should. But that's not what we're talking about here. What we're talking about here is management people using this kind of language in the workplace. One of my pet peeves in the world is pulling up to the drive-thru and having the person at the drive-thru call me sweetheart. I hate it. But they do it. That's not necessarily sexual harassment. But if my boss called me sweetheart, then we might have an issue. Another thing that you might not think of in this context is implying that a person is incapable of handling certain job duties because of his or her gender. That's man's work. That's woman's work. No, that's way, way out of dated thinking. And that's not the way we should be talking to our employees now. Okay, the EEOC also specifically talks about physical conduct, touching, which is sexual in nature. And they've got a real problem with hugging, kissing, pinching, grabbing, squeezing. It sounds like a Journey song. But that's what we're talking about here. Now, I want to talk briefly about two things on that list, because I shouldn't have to tell you that you can't pinch or grab or squeeze somebody. But what about hugging? Now, whenever I do this presentation live, I ask this question. How many of you are huggers? And inevitably, 4 or 5 people will raise their hand. If you hug somebody, have you created a hostile work environment? This is a good lawyer example. Maybe. All right? And here's why I say maybe. If you've got an employee sitting in your office and they're breaking down because they've got a ne'er-do-well child or they've got a crisis in their family and you hug them to comfort them, is that creating a hostile work environment? No, probably not. But if your lead move every time you see somebody is to hug them no matter what, you need to rethink that lead move. The other thing I would say to you is this: there's hugging, and then there's hugging. And you know what I'm talking about. There's touching, and then there's creepy touching. Okay? So how you hug is just important as if you hug. The other thing I want to raise is kissing. Should you ever kiss somebody in the work environment? I asked this question at a live seminar once, and I said to the people, has anybody ever kissed anybody they work with? And I had 2 hands go up in the front row. And the employees, I said, I'm sorry, you kiss people at work? And they said, yeah, we kiss each other all the time. Now, they were married. But I also said to them, stop kissing each other at work. You know, it's not appropriate. So those are 2 things you want to be really careful about and avoid. All right? So now that we've got all this stuff, how much of this stuff is necessary to create a hostile work environment? If I tell a dirty joke, have I created a work environment? If I touch an employee once, have I created a hostile work environment? Well, the answer to that question is there's a sliding scale of how much of this stuff you need, according to the EEOC, to create a hostile work environment. And on the one side of that scale is severe conduct, and on the other side of that scale is pervasive conduct. Severe conduct is one really bad thing: creepy touching, kissing an employee. That's severe. And that could get you in trouble right away. One time, boom, hostile work environment. And it also depends on things like how big your work environment is. And does the employee have other people to report to and complain about the conduct and all kinds of stuff like that. But that's on one side of the scale. The other side of the scale is pervasive conduct. Smaller things. But when they're repeated over and over and over and over again, they get to the point where they start affecting an individual's ability to do their job, then that's pervasive conduct. Let's go back to our receptionist. And every day a couple of salespeople walk by. And every day when they're walking by, they're telling dirty jokes over and over and over and over again. And remember, that receptionist can't get up and leave. And that may create a hostile work environment for that receptionist. Even though the receptionist is not the target of the dirty jokes, the receptionist has to listen to the dirty jokes. Pervasive conduct. According to the EEOC, whether conduct was what they're going to look at to determine whether conduct was severe or pervasive is whether it was verbal or physical or both, how frequently is repeated, whether the conduct was hostile or patently offensive, and whether the alleged harasser was a coworker or a supervisor. Supervisors can create hostile work environments faster than coworkers can. The EEOC goes on to say, where an employee's supervisor sexually touches an employee, it will normally find a violation. Creepy touching. If you engage in creepy touching, you're going to be found to have violated Title VII or the Elliott Larson Civil Rights Act, or both. Whether others are joining in or perpetrating in the harassment, is it a group thing or is it an individual thing? And was the harassment directed at more than one individual or just one individual? Okay, those are all things they look at. Now, there's limits to this. Federal law doesn't prohibit simple teasing, offhand comments, or isolated incidents that aren't extremely serious. Now, that might be a violation of your company policy, and you should check with HR about that. But that's not what federal law prohibits. The conduct has to be, quote, so objectively offensive as to alter the conditions of the victim's employment, period, end quote. Now, that may seem like a very, very high standard to me, but don't forget, guess who decides? Those 6 people on that jury that couldn't get out of jury duty. They're going to decide, not where you want to be. According to the EEOC, the conditions of employment are altered only if the harassment culminated in a tangible employment action or was sufficiently severe or pervasive to create a hostile work environment. So the really important word in that sentence is or. So we either have a tangible employment action or severe or pervasive conduct that creates a hostile work environment. So that's where we get 2A and 2B. We just got done talking about 2A, a run-of-the-mill hostile work environment. Okay, let's talk about 2B. And that's tangible employment action, sexual harassment. What is this? Now, this is a federal law issue. Okay? Tangible employment action occurs when the harassment culminates in a tangible employment action. All right? The EEOC and the Supreme Court have recognized one very simple thing. Corporations are legal people, but buildings don't talk to you. GM's stock ticker isn't going to have a conversation with you about your performance review. People are going to do that. Companies act through their people, and their people are you guys, management people. You are an agent of your employer. And when you undertake a tangible employment action, that is an act of your company. It's also a personal act, but it's an act of your company. So, if a supervisor knows of a hostile work environment situation and then undertakes or recommends a tangible employment action based on a subordinate's response to the unwelcome conduct, the employer's liable, and there's no defense. So if an employee comes to you and says, I'm being harassed in the work environment, and I'm going to go to HR if you don't do something about it, and you then go take that employee's bonus away or transfer the employee to an undesirable shift, you have taken a tangible employment action, and the company is now liable. The result is the same whether the employee rejects the demands and is subject to an adverse tangible employment action or submits to the demands and consequently gets a benefit. That's just like quid pro quo. I either threaten you or I promise you something, right? Remember in that definition, those two things? Now the EEOC says this would have previously been characterized as quid pro quo harassment, and they act like quid pro quo doesn't exist anymore, but in fact it does. And there are some differences between tangible employment action and quid pro quo sexual harassment, and the big one is right here on this page. According to the EEOC, a tangible employment action is a significant change in employment status. And also according to the EEOC, unfulfilled threats are insufficient to be a tangible employment action in this hostile work environment context. But unfulfilled threats aren't insufficient when it's quid pro quo. So if you're a supervisor and you go to an employee and you say, unless you sleep with me, I'm going to fire you, that is quid pro quo sexual harassment when you say it. It's not tangible employment action until you fire the employee. Either way, you can't do it. It's illegal. Don't do it. But there is a subtle difference there. Examples of the kinds of things that are tangible employment actions. Hiring and firing, obviously. Promotion or failure to promote. Demotion. Undesirable reassignment. Taking an employee off first shift and putting them on third shift. A decision causing a significant change in benefits, going from part-time to full-time, full-time to part-time, and that sort of thing. So when an employee comes to you, and let me give you an example, a kind of a concrete example of what we're talking about here. Let's say you've got this cool little work environment. It's kind of loosey-goosey, and you like it, and all your employees like it, and everybody kind of jokes around, and we talk about what we did on the weekend, and it's kind of real frat house, college-y, high school-y atmosphere. And then you get a new employee that comes in, and that new employee is uncomfortable with that frat house, college atmosphere. And they come to you and they say, I don't like this, and you've got to do something about it. And you've got to do something about it now, or I'm going to go to HR. And your response is, hey, I got this cool thing going on and nobody's complaining, so I'm just going to transfer this employee to third shift. That's a tangible employment action when you transfer the employee to third shift. And that could create liability for you. There's some other high-risk things that we don't want you to do, okay? One, remember, off-premises work-related conduct can get you in trouble. Now, what's work-related conduct? Well, it's pretty broad when you're a supervisor or a manager. You are a supervisor or a manager 24 hours a day and 7 days a week. So let's say you're sitting at the bar and you're minding your own business, and one of your subordinates walks up and sits down next to you, and they say to you, I've got to talk to you, but I want it to be off the record. What's your response to that? Your response to that has to be, look, I'm happy to discuss your issue with you, but it can't necessarily be off the record. It might be, but it can't be. And I'll give you examples of both. Because I'm your supervisor, it doesn't matter whether we're working or not, I'm your supervisor 24 hours a day and 7 days a week. Or I'm a supervisor, even if I'm a supervisor in a different department. And if this relates to work, I may have to report it to somebody. Now, if you want to tell me about your ne'er-do-well kid who's causing you trouble, or problems you're having in your personal life, and you just want somebody to listen to, that I can keep off the record. But if you're going to tell me about something that happened at work or relates to work, there is no off the record there. Okay? The other thing I want you to remember is this. If you're a supervisor or a manager and you're sitting at the bar and you hit on one of your associates or your subordinates, it doesn't matter that you're not at work. I said at the beginning of this thing, the next day when you go to work, you're still going to have power over that employee. You are still a supervisor. You are a supervisor 24 hours a day, 7 days a week. So I'm going to give you 2 pieces of advice, and some of you aren't going to like them. Number 1, don't drink with your employees. It will only cause you trouble. And number 2, do not date your subordinates. Remember Vincent? Even if the conduct is voluntary to begin with, it can very quickly become unwelcome. Do not date your subordinates. It's a bad idea. Be careful about touching your employees. Can you hug an employee who's having a hard time or somebody who's retiring? Yes, you can, but I want you to be super careful about touching your employees. And when you hear sexual jokes or conversations, stop them. Don't participate in them. Okay? Okay, so with all of that as a backdrop, what's the liability for all of this? How much is this going to cost us? Well, employers are held vicariously liable for the actions of their supervisors. We talked about that. And according to the EEOC, the type of harassment engaged in by the supervisor determines whether the employer can raise an affirmative defense to the vicarious liability. So an employer, depending on what type of harassment occurred, the employer is going to have to make a decision about what it does and whether or not it can protect itself. All right? If you've engaged in quid pro quo or tangible employment action, sexual harassment, if a supervisor has done one of those 2 things, or both of them, it's automatic strict liability for the company. Once the employee proves that the tangible employment action harassment occurred, or proves that the quid pro quo harassment occurred, the employer is liable, and it doesn't matter what the employer does to the perpetrator. Even if the employer fires the supervisor, the employer can still be liable for that. There is no affirmative defense for quid pro quo or tangible employment action sexual harassment. All right? So don't do it. It's not a question of will we have to write a check. It's a question of how big will the check have to be. Now, if there is not a tangible employment action and we've just got run-of-the-mill hostile work environment sexual harassment, there is an affirmative defense to vicarious liability. It is available. And that affirmative defense revolves around some things that we're going to talk about, but it revolves around us having a policy that we publish, that the employees know about, us telling people about the policy, in other words, training them on it, us doing this training with you right now, which is part of the reason why we're doing it, and then when a complaint comes in, acting on it promptly and taking prompt, appropriate remedial action to end the harassment. Okay? That's why I'm going to say to you, and I've already said this in a couple of ways, if somebody comes to you and says, I'm being harassed, don't try to handle it yourself. Get your HR department involved and report it, because the minute you know it, remember, you're an agent of the employer. The minute you know it, the company knows it. And if you don't do something about it, or if you try to handle it yourself, that could create liability for your employer. How do we want you to behave in these situations? Well, there's a couple things I want you to do. Number 1, before you say something or do something, ask yourself this. And every time I say this, I think I have to change a slide, and I never do. What would you do if your spouse or significant other were present? Now, the reason I say I have to change a slide is over my 30 years of doing this, I've seen some pretty freaky marriages. So maybe I should change that to grandma. What would you do if your grandma was present, right? Would you do that if grandma was sitting next to you at the table? Would you disappoint your grandma if you did? Would you object if somebody said this to your daughter or your son? And here's the big one, because depending on where you live, whatever you do may very well end up on the front page of the newspaper. This is, even today in this environment, this is big news. Sexual harassment is big news, and if you work for a significant employer in your community and this becomes an issue, you can bet that the local newspaper is going to be around asking about it and writing a story about it. Again, we go back to that affirmative defense. If an employee was subject to a pattern of harassment that created an unlawful hostile environment. But the employee, number one, unreasonably failed to complain to management before they suffered the harm, and the employer exercised reasonable care to prevent and promptly correct the harassment, then the employer will avoid all liability. That's from the EEOC's 99 enforcement guidance. What does that mean? If an employee doesn't complain about run-of-the-mill hostile work environment, and we don't know about it, we don't know or should have known, then we can't be liable for that. You can't be liable for something you didn't know or should have known. But remember, if the employee complains to you, the employer knows. You are the employer. So once they complain to you, you've got to do something about that. The second way we can avoid liability in a situation like this is when the employee complains that we investigate and take prompt, appropriate remedial action. That's the second part of that statement. And I've said that twice now, and I've said it twice because I want you to know about it. It's really important that when these issues come up, you report them to somebody. Harassment is prohibited against employees and applicants, and we're required to take all reasonable steps to prevent harassment, and this is step number one, conducting this training. All right, so what does an employee do if they feel like they've been harassed? And I tell you this just so you know, they have two options. Under federal law, they have to file what's called an administrative complaint. That's one of those charges we talked about at the very beginning that ends up on that chart from the EEOC. They have to file an administrative complaint, and once they've done that and a right to sue letter is issued, then they can sue you in federal court. Or if they're suing you under state law, they can go right to a private lawsuit. No federal charge, no chance for us to answer, no nothing, straight to court. If they sue you, what do they get? Well, here's a list of what they can get. They can get back pay, they can get rehired. That doesn't happen very often. Front pay, policy changes, affirmative relief, like an injunction or something like that. A requirement that we do training. That's a whole list of things that they can get. But the really, really big one, the one that really kind of ups the ante on this is that last one there, attorney's fees and costs. Under the two statutes that we're talking about right now, if an employee sues you and wins, not only do they get their damages, that list of things there that they might be awarded, and not only do you have to pay my law firm or a law firm like mine to defend you, if the employee wins, you also get to pay the employee's legal fees. So what became an expensive proposition just became a doubly expensive proposition. So what do we do about this? What we do about this is what we're doing right now. It's all about leadership, right? We set an example we expect others to follow. Leadership defines your company culture, and it defines what you want to do. So where do we start? According to the guidance, we start with prevention. We have an effective preventative program, including an explicit policy against harassment that's clearly and regularly communicated to employees and effectively implemented. We have to affirmatively raise the subject with supervisory and non-supervisory employees and express strong disapproval for harassment and explain what will happen if harassment occurs. We're doing that with you right now. All right? We're doing that with you right now. How do we do this with employees? And I get this question all the time from managers, supervisors, companies. Look, if I raise the issue of my harassment policy with employees, I'm going to get a bunch of complaints that I have to deal with. Yes, you are, for a short period of time. But you still need to raise it with employees. So here would be my suggestion to you. And don't do this without talking to HR, but think about it. If you have monthly employee meetings or on-the-floor meetings or shift meetings or something like that, every once in a while, depending on how frequent they are, bring up a company policy and make the employees aware of it. Don't start with the harassment policy. Start with something fun like vacation. Hey, here's our vacation policy. Don't forget, this is what you have to do to request vacation, blah, blah, blah. And then the next meeting, raise some other fun thing like, I don't know, the holiday policy. And then at the third one or fourth one or fifth one, raise this policy and say, hey, don't forget, we've got this harassment policy. And if you witness this sort of thing, you have to report it to us and we'll do something about it. That's how we raise that with non-supervisory employees. And that would be my suggestion to you. But again, talk to your HR department, your management before you do that. You also have to have a procedure for resolving complaints. And this procedure has to be designed to encourage people to come forward and report. All right? We've seen this in the Me Too movement all the time now. We see this we have to encourage people. We have to make it comfortable for people to report these things. If we make it difficult for them to report, requiring a written report, for example, requiring a written complaint. If we make it difficult for people to report, we discourage reporting. We don't have this environment of taking care of this problem, and that could cause us liability going forward. And your policy should never require a victim to complain to their offending supervisor. A lot of policies from companies over the years have something that says you must first report anything to your supervisor. Well, with a day-to-day problem that doesn't have anything to do with harassment, that's fine. But when we're talking about harassment, it's not fine. You got to give it at least 2 ways to report. One can be the supervisor, but the other should be something like upper management or HR or something like that. All right? You have to ensure confidentiality as much as possible and provide effective remedies, including protection for the victims and the witnesses against retaliation. And that's super important. It's super important because you can win the underlying harassment claim when the employee sues you and lose the retaliation claim. And retaliation claims are a favorite of the plaintiff's bar. They love them for just that reason. Because when an employee comes and complains to you about something and it affects you personally, your bias is going to be, well, I'm going to get that employee. But if you go get that employee after they've engaged in protected activity, that's retaliation under the statute. All of these statutes have retaliation components in it, and you'll be liable for that, even if you didn't commit the underlying harassment. So be super careful about retaliation and make sure employees know they won't be retaliated against. You need a policy, and not the same policy you had 20 years ago. And I'm sure you all have policies. That's why we're doing this training. And at some point, somebody from your management group will talk to you about that policy. Okay, you need to train. Here's step number 1 in that. We're training you guys, managers and supervisors and members of management. But you also need to train your employees. It's a different kind of training. We don't give employees this training. We give employees, we call it bystander training. And we have a bystander training program. And you teach people how to report. You teach people about your policy. You teach people how to react. You teach people how to support their coworkers. It's not so full of all the legal nonsense that we have. And then you have to implement. When you receive a complaint or otherwise learn, and remember, it's know or should have known that the harassment occurs. So if you could get up out of your chair and walk out on the floor and see the harassment, that should have known. When you receive a complaint or otherwise learn of alleged harassment, you have to investigate promptly and thoroughly. Who is going to investigate promptly and thoroughly? Not you. You might be asked to participate in the investigation, but HR is going to investigate. If you have an HR department or somebody outside your department is going to investigate. You never investigate something that's going on in your own department. That smacks of bias. Right? So we might ask you to participate. You might even be a witness, but you're not going to conduct your own investigation. We want human resources or somebody like human resources to do that. You have to take immediate and appropriate corrective action by doing whatever is necessary to end the harassment if you determine that harassment has actually occurred. Now, does that mean you need to fire the employee? Not necessarily. We'll talk about that in a second. But you got to do something to end the harassment and make the victim whole. So if the victim lost a bonus or benefits or something, you got to make the victim whole. Again, if you determine that the harassment has occurred. All right. What about disciplinary action? All right. So the law requires you to take prompt, appropriate remedial action designed to end the harassment. Does that mean you have to fire the offending supervisor or the offending employee the first time they do something wrong? The answer to that is no. You're not required by the law to fire the employee. What you're required by the law to do is take reasonable action to end the harassment. So a lot of what we do is going to depend on how bad the harassment was. Was it something minor, like a couple of dirty jokes, or was it something major, like sexual touching? And that will determine what level of discipline you have to give. It will also help set a tone, I guess is what I'm trying to say, for your environment, what level you give. That this kind of violation is going to be handled this way. Now, I will tell you this is not baseball. You don't get 3 strikes. If you've got somebody who's harassed somebody and you correct it and they do it again, That's it, 2 strikes, you're out. I mean, the second time, if you call me, I'm probably going to be recommending that that person get fired, that we don't give them a 3rd chance. But you don't have to fire them the first time out. You have to take action designed to end the harassment. And you don't have to be right. You have to be reasonable. Was the action we took reasonable in light of all the circumstances? Or wasn't it? The other thing we need to do that we often forget is we need to follow up with, once we're done and once we've done the discipline, we're not done. You need to follow up from time to time with the employee to make sure everything is okay, that they're not being retaliated against, that the harassment hasn't started up again. And that's particularly true if we're not firing the perpetrator. So those are the things that you need to consider. That's it. That's the whole thing. Now, guess what? There's a quiz. I know you don't want to take the quiz, but there's a quiz. Or maybe your management is going to stand up and talk to you about your policy or something like that. But that's all I have. I hope you enjoyed this and learned something from it. Thank you very much. We'll see you next time.